You have received eviction paperwork from your landlord, but you should know that there are several possible defenses that you can present. One is that your landlord did not follow the procedural rules and laws to evict you. The law requires the landlord to give you proper written notice of your violation that clearly states what you did wrong. The landlord must also provide you with the proper summons and complaint. When serving the summons and complaint, the landlord is required to provide a copy of the breach notice, the lease, and any addenda or lease additions related to the eviction to the process server or constable for service on the tenant. Additionally, if the action is for non-payment of rent, an accounting of the charges and payments for the last 6 months must also be served. The summons and complaint paperwork tell you that an eviction has been filed against you and that a date and time is scheduled for a court hearing. To present a defense and try to stop the eviction process, you will need to go to court at the time listed on your summons. Do not be late. Try to arrive at least 30 minutes early to allow sufficient time to check in and find the courtroom. Another defense is that you did not commit the violations listed on the complaint. Take copies of any receipts or notices that you need for your defense to show to the judge. If you have witnesses, make sure they come to court on time too. There are other defenses, such as retaliation, unlawful ouster, and diminution of fair rental value. An example of diminution of fair rental value is that your rent includes the use of a swimming pool, but it has been closed all summer. You might be entitled to recover damages because you believe you are paying more rent than you should have if the landlord was not complying with the rental agreement, but you might have to do that in a separate lawsuit. It might also be a defense that the landlord accepted a payment of rent after giving you the notice. You do not have to file a written answer to present your defenses to the judge, but the judge may ask you to file an answer later. Another legal document is called a counterclaim. This is a document that you file with the court that states how your landlord violated your lease, when and how notices were sent to your landlord, and what the notices were about. If you want to bring counterclaims, you will need to file a written answer and counterclaim before the time of your hearing. There will be a fee to file the answer. You can request the fees to be waived or deferred. You must give a copy of your answer and counterclaim to the landlord or their attorney before the hearing. Make sure you are in the courtroom at the time of your hearing. When the judge calls your case, make sure you tell the judge if you live in subsidized housing, tell the judge your defense at that time, and whether you are asking for a jury trial. The judge may hear all the facts of your case at that time or set it for another day. The judge will then decide whether you should be evicted based upon the information you and the landlord present. Go to the Self-Service Center at azcourts.gov or azcourthelp.org to view helpful legal info sheets such as claims against your landlord, non-payment of rent, and after an eviction action.